do you have some question? Yes?
Really, it's questions relating to the AFA rules and going back to their establishment. This is 1975. What was the original motivation for their establishment? I hear from Charles Captain that the vast majority of arbitrations that take place under the AFA rules have their seat of arbitration in France. You can have your seat elsewhere. Was the motivation principally to cater for national arbitrations, or at least where one party was French? And if so, what were the alternatives then available? Secondly, it's a set of rules, but it's also an administered set of rules. That, of course, was a conscious decision to take at the time. It bears a comparison with the ICC. Whereas in the UK, we conduct lots of arbitrations without any administration whatsoever. We have plenty of sets of rules, and that's all that's incorporated in the contract. Thirdly, was there a dissatisfaction at the time with the existing international arbitration rules? Was that an equal or perhaps lesser motivation for the establishment of the rules in 1975?
Well, okay, since I've been invited by our president to speak, of course, I wasn't in practice at the time. No, I think there was a perceived need at the time. I don't think. Well, let's talk about today, and I think it will illuminate the past. Today, I think, as you've rightly pointed out, the AFA as an institution is an institution whose vocation is to deal with domestic and international matters, but as far as international matters are concerned, they will mostly have a link to France. I mean, for those of you who are familiar, there are other institutions which are fairly similar in other continental countries, such as the German Deutsche Institut, and there's the Camera Arbitrale di Milano, who are doing a very similar sort of job, and then in England, there's the LCIA, which can't quite make up its mind as to whether it's a wholly international institution or a partly domestic one. So that was the positioning of the AFA, to serve the French business community, which, of course, the ICC is not designed to serve. The ICC is designed to serve the global business community. And to that extent, I don't think there's dissatisfaction with the ICC. It's just not doing exactly the same job. And I hope that's enough of a sufficient reply to your first question. Your second question was conscious choice for administered arbitration. Yes, of course. Again, I refer back to my first answer. Administered arbitration was considered a good thing in itself, except the ICC model was perhaps a little bit too heavy, a little bit too expensive, although I immediately put in parenthesis there that I hear a lot of talk about the relative cost of institutions. As we all know, the proportion of the cost of an arbitration represented by institutional costs is pretty small. But having said that, there was a consciousness within the French business community that there had to be something which was more their size. I've forgotten now what your third question was. Perhaps you could remember. Sorry. Yeah.
You said it's essentially designed for the French business community.
Yes, I mean, okay.
For arbitrations which have nothing to do with France.
Absolutely. Now, I have to say that of our current caseload, anywhere between 25% and a third, year in, year out, has an international element, and we appoint international arbitrators, and of course, of the 5 members of the arbitration committee, 2 are not French, and that's again is a conscious choice of the institution and the way it sees itself.
Michael Butcher, Viola or Biramon. Where there is a case where it is for the arbitrators and there is more than one to decide upon their rules of procedure, What happens if they can't agree?
I think you're talking about something which I can conceive of, but which in practice would never happen because, well, first of all, the dynamic of a tribunal. Suppose, again, and this goes back to, I think, what Sir Anthony said terrifically clearly about the spectrum of arbitrations in England. I would say the same thing about the spectrum of arbitrations in France. You go from also because your arbitrators, the arbitrators who are sitting in French cases, or cases with French seats, they come from all over the world, so they're going to be doing it in all kinds of different ways. Suppose you've got a tribunal of 3, and all 3 of them have their own ideas to how an arbitration should be conducted. Well, that's pretty unlikely to start with, because really the great divide is going to be between doing it more or less common law or more or less civil law. That's really the way it's going to pan out. And really the person who's going to give the impulse as to which way you're going to go on that is going to be the chairman, in effect, and one of the 2 arbitrators who is going to fall in line with him. In my experience, you never ever, though, really get into serious arguments about that sort of thing. It's not an entirely, I mean, it's a very practical answer to what in theory could be a problem, but I mean, it just isn't, because people appointing a chairman, the 2 co-arbitrators or the 2 parties, that's what they're picking, and by appointing a chairman, they're almost subliminally they're agreeing on a procedure. Is that an answer to your?
No, but it's very pragmatic.
Lawyers in France and England have very different expectations of their relationship, not only with their clients, but with each other. And in arbitrations under the AFA, 2 questions arise, for example, as to whether statements should be taken from witnesses or not, or what protocol is to govern offers of settlement which in English would be without prejudices to costs.
Well, sorry. Well, on your first point, as to whether statements should be taken, that is typically what we've just been talking about. I can say that in international cases that has now become pretty much standard practice, and I think that's what Sir Anthony was talking about when he talked about the sort of ICC procedure. Yes, that is a kind of compromise mishmash which purists maybe don't like very much, but it works, and statements are taken, and that's part of the consensus. And it's the same under AFA rules, depending on who your tribunal is. Sealed offers, on the other hand, is huge fun, because you often have Kulturkampfs about that between English lawyers and everybody else. And all I can say there is, yes, it's perfectly conceivable to do that, but you'd better agree with your esteemed colleague on the other side, if he's not English, that you're going to do it in a certain way and that it's to everybody's advantage. In other words, you're going to have to construct. You're going to have to reinvent the wheel, in effect. And I have to say, my position, if somebody based in London says, oh, well, of course we're going to do it this way, is, wait a minute, I'm going to work out whether I agree with it and whether it's in my interest to agree to doing it that way. But
could I just come in there then? I found that the vast majority of commercial arbitrations, but certainly not all of them, do lend themselves to adopting a sort of modified procedure which has got more to do with what we've all come to treat as broadly international procedural principles than to do with English commercial court principles. By that I mean that it's commonplace now in ad hoc arbitrations, that is non-institutional arbitrations, for procedural orders to be made which require the claimant to deliver a statement of its case accompanied by all the relevant documents in its possession, to be met with an answer by the respondent, accompanied with all the relevant documents in its possession, and a request for any further documents the claimant may have, and then a response from both the claimant first and subsequently a further response from the respondent. And if there's any argument about documents left after all that, then it's dealt with either by negotiation between the parties, or if they can't arrive at an agreement, by a further procedural order. The advent of statements from witnesses is usually something which is included in the materials which are served with the statement of case or the reply, together with the documents in the possession of the party. And it cuts down the time tremendously by comparison with sticking more closely to the English commercial court type, civil procedure rules type of procedural regime. So I'm rather in favour of that, and I tend to make that kind of procedural order as often as I possibly can, because I just think it works.
I wonder if I can ask a question of Charles Caplan. One of the points of difference that's emerged, my name is David Hope, by the way. One of the points of difference is the opportunity for appeal or review. As I understand the French system, it's very strict. There is no such opportunity at all. Whereas in England, although it's not a very wide-ranging opportunity, it's there. No doubt other countries differ in their approach. How safe is a party who arbitrates under the AFA rules from being drawn into a jurisdiction which tries to open up, for example, the provision in Article 4 that tells you that the award is final and not subject to review? Have you any experience of being drawn into a challenge in as you might say, an unfriendly jurisdiction that actually takes a quite different view of arbitration?
Well, there are two different aspects there. There's French law and the AFA rules. When the AFA rules say the award is binding and not subject to review, again, that is written in a French context at the time it was drafted. And you have a similar provision of similar effect in the ICC rules, which in effect means that any form of appeal which can be waived by the parties is waived. So, and that, of course, means substantive review. In any event, I think, and I don't think there's any, I don't think it's specific to AFA arbitration, and I don't think it's specific, and I don't think it's specific to any particular sets of rules. If you arbitrate in most continental countries, or indeed in any model law country, in effect, any country that's adopted the model law as its arbitration law, you will not get, under any circumstances, a second substantive bite at the cherry. That's actually considered arbitration friendly rather than unfriendly. I mean, again, the AFA is not going to have much influence on where the seat is, because in effect, at present, unless the parties have stipulated a seat outside France, we would hold the arbitration in France, where we know what the system is. Just to be entirely clear, the review which exists, I said I wasn't going to go into any depth, and I won't, but just to have bear in mind, you know, the reviewing court will verify that there's a valid and arbitration agreement. They will verify that the arbitrators have been properly appointed. They will verify that natural justice has been observed, what in French is called le contradictoire. They will verify that the arbitrators have not overstepped the terms of their reference, ultra petita, infra petita, not applying the rules or applying them backwards. A difficult case to make that, though. And fifth, they will verify that the result is not incompatible with international public policy. There you get a little bit of substance if something dreadfully wrong has been decided. If there's been corruption, if there's been, you know, there you may get into the substance. I mean, but those are the safeguards, and no more. I mean, particularly no Section 69.
Can I just ask, I guess it's a small point in relation to what we just discussed. It's something you mentioned earlier on, that is about the need for an arbitrator to become a member of the AFA for something to do with insurance purposes. I didn't quite follow that. Perhaps you just clarify what you mean.
It's each arbitrator must be a member of AFA before beginning the arbitration trial, because the AFA has an insurance for all arbitrators in an AFA tribunal. So it's a security for the arbitrator. For example, French attorneys have a kind of insurance, professional, but some people can be chosen as arbitrator without being insured. So it's a security for the arbitrators and also for the AFA as organizing the arbitrations.
But it's not necessary to choose an arbitrator who is yet member of the AFA. You can choose any arbitrator you want, but he has to be registered in the AFA before the beginning, as Michel Marco told you, before the beginning of the arbitration. The security.
To reassure, maybe you will have to say that the membership fees are not expensive at all. 15 euros.
It's not expensive at all. You can be a member of the AFA.
And it's less expensive than taking a personal insurance.
No, it's much more expensive. And if you are a member of the AFA, you will be invited every year at a great meeting. And this meeting is very interesting because usually we have one or two speakers about a question of arbitration. Last year, the meeting was with Professor Pierre Mayer and Professor Luca Radicata, I don't remember exactly his name, and they were spoken about ordre public, you spoke about, in the arbitration and in the recourse against the award. And this year, the meeting will take place in September, and the speakers will be Alexis Moore, attorney of Paris Bar, and the other, I don't remember the other, but I have in a few minutes, and the subject, yes, it's Professor Pierre Tercier. All of you know Professor Pierre Tercier, and they were speaking, they will speak about the institution arbitrations in the 21st century. It's one of the activities of the members, and we have meetings all the year long for the members of the AFA. I think that Monsieur Michel Aurillac should like to speak.
Question to Anthony Colva. Does the English show the difference between domestic and international arbitration? What is it?
Yes, the Arbitration Act does distinguish between domestic and international arbitration, or non-domestic as they're called. And the domestic arbitrations are the subject of special provisions in the Arbitration Act. They're not very considerable, but they are exclusively set out in Section 85, 86, and so on. They don't have any fundamental differences from international arbitrations, but the process of domestic arbitration is one which is, I tell you, it simply takes up, in the Arbitration Act, 4 sections out of 105, or however many sections there are, and there is then a different regime which applies to consumer arbitrations, which of course are retail trade arbitrations in effect. And they are even less fulsomely dealt with because there are only 3 sections which deal with them. So substantially, the rules in the Arbitration Act do all apply, except for a few exceptions which are set out in these few sections to both domestic and consumer arbitrations. To get the sections are quite detailed, and there's not much purpose in reading them out to you, but that's where they're to be found anyhow.